The taxation of bank capital. Banks of deposit and discount have little property for direct taxation. The real estate, cash on hand, and tangible personal property other than evidences of credits or debts is all there is for direct taxation. The statement of the Boston banks, December 17, 1877, capital, $51,850, loans, $127,699,700.00 specie, $2,940,800.00 legal tender, $5,500,500.00 due from other banks, $17,535,100.00 due to other banks, $20,984,300.00 deposits. $49,745,500.00 circulation. $24,561,400.00. By this statement we find that the banks of the city have loaned $127,699,700. Why should not the banks pay taxes upon this entire loan? It is property upon which they draw interest. Supposing we add to the loan all other credits, should we not be justified in claiming sufficient credits to balance the entire assessment of? We find that the assessed value of the personal property of the city of Boston was, in 1876-7, $222,838,310. Take from this amount the bank loan, $127,699,700, and we have a balance of $95,138,610. It has been estimated that credits in Boston upon mortgages alone are assessed to the amount of $50 million. If this is so, then the banks are not sufficiently secured upon their loans. But as the managers of these institutions are not wanting in a knowledge of their business, we must conclude, from this approximate of credits, that not more than half of the personal property within the city of Boston is assessed. If no offsets were allowed, and credits were assessed only, we might assess more credits than is now assessed of personal property, including credits not offset. It requires little penetration to see that our system of taxation is wanting in that requisite. It is, in fact, no system upon which any reliance can be placed. It is merely guesswork, spoliation, and hypocrisy. Our banks of deposit have, as well as other banks, pushed their claims to the right of an exemption wherever there was a chance to accomplish anything. They never have been willing to be considered objects of charity, but usually base their rights of exemption upon the ground that through their capital the improvement in business and the increase in value of taxable property in their locality would more than balance any loss of taxes through their exemption. This theory, in substance, was advanced in behalf of the savings banks by the Committee of Associated Savings Banks, in their communication to the commissioners in advocating the reasonableness of the 0.75% tax upon their deposits, and against an increased tax. No one will deny that the savings banks are a great local benefit, as well as other banks. But what we do object to is the theory that they are not quite as dependent upon the community surrounding them as the community are upon them. And we say they are more. The community can exist without them, but they cannot exist without the community. These people would not establish a bank upon the top of Mount Washington, not even with the privilege of an exemption from taxation. The wind could be too easily raised there. Therefore, let this theory of benefits be considered balanced, with the understanding that we are wonderfully dependent upon each other, much more than the good will which we extend to each other would seem to indicate. While government should grant all reasonable requirements of the capitalists, it should exercise great care and caution in allowing exemption or granting appropriations for private enterprises intended for public benefits. But whenever the conditions will warrant an appropriation of the public funds, the benefits arising therefrom should be unquestionable, and the security ample. If the public require any enterprise to be carried forward at the present day, as a rule there is sufficient private capital to accomplish what is really required, and if required, it will pay to invest. We know very well that the capitalist looks to the community for a fair interest upon the capital invested, over and above any privileges or grants from the legislature, and this they feel sure of, or they will not invest. Banks should be required to pay taxes upon their net assets over and above their liabilities, the same as any other capitalists. Their loanable funds consist of their paid-up capital, circulation, and deposits. From these they are enabled to loan from 2 to 3 times their capital invested. Nearly 1/2 of their loanable funds are derived from deposits, upon which they pay little or no interest, usually none, but in certain cases they do a small amount. The United States government requires of national banks a tax, but this is balanced by government securities held by government in favor of the banks. In the absence of any government law preventing the state levying a full tax upon banks, no deduction should be made from the state tax on account of the government tax. The government tax is an excise tax for privileges granted, and should be worth to them the payment required, and ought not to interfere with the state's taxation. Taxing these banks as we propose, taking the statement of December 17, 1877, as a correct statement of their assets and liabilities, they should be taxed through the debtors' lien for the amount of their loans. $127,699,700 amounts due other banks. $17,538,145,237, 800. The local assessors would assess them for their real estate, cash on hand, and any other personal property other than credits. The banks would reimburse themselves through their debtors' lien upon their shareholders. $51,850,000 deposits. $49,745,500 due to other banks. $20,984,300 $122,579,800 Merchants depositing in these banks need not return such deposits as cash on hand. It is not cash on hand, it is cash in the possession of other parties, and should be assessed to them. Whatever the merchants may have in their till they should return as cash on hand. Average deposits should have nothing to do with taxation. There is about the same capital in the country at one time as another, and there can be no advantage in an average of deposits, not if a correct statement is once made. This is sufficient. The object is to tax everything once and at the same time, and the income for the year past. Savings institutions, trust companies, and brokers should be taxed for what tangible property they have on hand only. The debtor's lien will take care of the balance. Why the savings institutions can claim an exemption of their property is not clear. It is a very absurd undertaking for government to tax these institutions 3/4% upon their average deposits. We are unable to see any correct principle involved. To exempt a portion of any institution, where the rich and poor have the same advantages and rights, must give each the same privileges, and if the principle is correct, we might exempt the whole community upon that principle. Not only might, but the community have the right to claim the exemption. When we ask those connected with these institutions if they have any reasons why they should not be taxed the same as any other capitalist, according to their ability to pay, they say these institutions are a great benefit to the community, and to tax them more than they are now taxed would serve to cripple their usefulness. They are mostly supported by the poorer class of people, and their deposits are small. Yes, but do not the rich as well as the poor deposit with you? Yes, no doubt they do to some extent. Well, then, in exempting the poor of your institutions, we must exempt the rich to the extent of their deposits, undoubtedly. Then is it just to exempt the rich? No. Of course not. But how can we help it? By taxing your institution the same as any other loaning institution or individual. But this would not help our poor depositors. Are you sure of that? Why, if we tax them, they have got it to pay. Besides, we are not now in the condition that we were formerly in regard to profits. Heretofore we were enabled to declare a dividend of 7 to 8%. And to put a heavier tax upon them now would make it still worse. Are you sure? Is there no other class of your customers whose interests you might not consider, and not wrong your depositors? We are not aware of any. You hold mortgages? Yes. What amount? In value, $1 million or more. Do the mortgagers pay their interest promptly? No. Many pass their interest these days. That is one reason why we are unable to declare large dividends. Have you any mortgage notes with interest less than 6%? No. Most of ours are above that. Have you government securities? If so, at what rate of interest? Yes, we have those which pay 6, and so meet 4.5. Have you any securities other than government you could not pay the taxes upon and realize 5%? As a rule, we have got very few that would not realize 5%. After paying the taxes, we see no reason, then, why you should not pay the taxes upon these securities. If you are able to do this and realize a profit above government securities at 4.5%, which are selling today above par, we are desirous of making as large dividends to our depositors as possible, and we hardly feel called upon to advocate any system of taxation which will lessen them. Do you loan at less rates than other moneyed institutions because of less taxes? No, we get the ruling rates, or the most we can. It depends upon the demand in the market for money. You consider real estate good security? Yes, one of the best. What rates do you get? 6, 6.5, and 7%. It depends upon the property. Do you consider your security upon real estate equivalent to owning so much of the estate as will be necessary to pay your loan in case of forfeiture? Certainly, in certain contingencies we can claim the estate, or so much of it as may be necessary to pay the mortgage. Then, why should you not pay your proportional amount of tax upon this estate? You both furnished the money to purchase it, why not both pay the taxes? The law does not require it of us. We are taxed 0.75% upon our deposits. Is this just in principle? It is very generally understood to be unjust at the present day, and that it is a double tax upon mortgaged property. Will you advocate a change in the law, to the effect that each party shall pay the taxes, according to the amount of each one's equity in the estate? We would rather have the mortgage exempted and loan for less %. Would you loan for less? Through competition we would be obliged to. Would that competition be sufficient to lessen the rate % for the loan to cover the tax? That would depend upon circumstances. At times it might, and others, not. Would it not be far more just for each to pay his own, and leave nothing to circumstances? The taxes might be high, and they might be low. The loan would have nothing to do with the tax rate. You are right. But it would be more convenient for us to be exempted upon the mortgage. Not so. We propose to tax the mortgaged estate to the mortgager, and you are to deduct the amount of taxes upon your loan from his interest account, or, in other words, credit him with your tax which he has paid. You are right again, but we had rather pay the 0.75% upon our deposits. But would not the advantage accruing to the mortgager so increase his ability to pay your interest, while it would enable him to compete with his neighbor who owned his property, more than compensate your depositors for the loss of 0.5%? In taxes, especially when the whole is to be credited your debtors instead of paying out 0.75% to government? I am not certain, perhaps not to that extent. But right is right, and no one should oppose it. We will consider the matter. We left this friend convinced we had not fully persuaded him to advocate the principles we had contended for. But we fully believe he considers we are right. It is very difficult to convince men what is right, if their interests are in another direction. We really have not much of that virtue called charity, and if this could be passed, and we could bring the scales of justice up to a level beam, this might lead to charity as an object in the dim future. Insurance companies of all kinds we need make no especial mention of, as they would come under the general system of taxation, being taxed for what tangible property they may have in their possession, subject also to a state franchise tax for services rendered.